Good morning friends, I am Dr. Yogesh Pratap Singh, Assistant Professor of Law at National Law University, Orissa, Cuttack. Today we will be discussing a module on judicial process and precedential mechanism in India. In this module, we will discuss the meaning of judicial process, the concept of judicial process, the concept of precedent, stare decisis, and how judges used the principle of stare decisis or rule of precedent and how it affects the decisions of the court. Judicial process in a country seeks to establish the facts, they determine the governing rule of law, and then to apply the rule to the given facts. It consists of the practices that are followed by a court system in hearing and judging a case before it. Roscoe Pound gave an analysis of judicial process which involves in the decision of a case according to law. He gave 4 important things which a judicial process involves. First, finding the facts, which he means ascertaining the state of facts to which legal precepts are to be applied in order to reach a determination. The second is finding the law, means ascertaining the legal precepts or precepts applicable to the facts found. Third, interpreting the precepts or precepts to be applied, that is ascertaining their meaning by genuine interpretation. Now, this is very important stage of a judicial process of any state, any country, how judges used rules of interpretation and they interpret, they decide a case. Judges in the process of interpretation of a statute or a constitutional provision, they apply several rules which they have evolved. For instance, literal rule of interpretation, golden rule of interpretation, mischief rule of interpretation, creative rule of interpretation, and progressive rule of interpretation. These rules of interpretations are applied by judges, and there is no set standard, there is no set pattern that which rule should be applied in which case, and hence it depends on judge to judge. But literal rule of interpretation, it has been accepted by the courts, it has been accepted by the judges that the literal rule of interpretation should be followed because of the reasons that the words which are used in the statute or the words which are used in the constitution are the intention of the legislators, are the intention of the drafters. So, try to give literal meaning to the words, general meaning to the words which are used in the statute book, but judges have the freedom to deviate from literal rule of interpretation when this literal rule of interpretation leads to an absurdity. I can give an example to make you understand that how literal rule of interpretation is applied by the judges and how literal rule was applied which gave absurd result in a particular case. The Supreme Court of India in the very beginning decided a famous case, A.K. Gopalan versus State of Madras. The question before the court was, what is the true meaning of word life and procedure established by law in Article 21 of the Constitution, which says that no person shall be deprived of his life and personal liberty except procedure established by law. The majority in this case applied literal rule of interpretation and they decided that the right to life means right to live, right to move, and procedure established by law means a law procedure established by a law which has been passed by the parliament or by the state legislature. Finally, judges decided that the law means lex and not the jus as argued by the petitioner. Lex means law passed by the legislature. This was the literal rule of interpretation applied by the Supreme Court in A. K. Gopalan versus State of Madras. Now, literal rule which might give absurd results, we will discuss a famous example, a famous decision of the Supreme Court in Golaknath versus State of Punjab, where 11 judge bench interpreted Article 368 of the Constitution and Article 13 clause 2 of the Constitution and applied the literal rule of interpretation, and this literal rule of interpretation gave an absurd result. The absurdity was that the Parliament, in exercise of its power under Article 368, cannot amend the Constitution, because word power was not mentioned in the Article 368 marginal note and the word procedure was mentioned only. Supreme Court also suggested in applying literal rule of interpretation that if you want to amend the Constitution, they can use residuary power under Article 368 of the Constitution. This was the literal interpretation which gave absurd result, and this was the effect of this absurd result, that the 13 judge bench of the Supreme Court in Keshwanan Bharti versus State of Kerala overruled this judgment of the Supreme Court in I. C. Golaknath versus State of Punjab. Supreme Court also have applied creative interpretation, sometimes we also call it progressive interpretation, in number of cases, and during the era of judicial activism, Supreme Court interpreted Article 21 of the Constitution or other provisions of Part 3 of the Constitution in such a creative manner that the words which are used in Article 21 remain the same, but the meaning of Article 21, the meaning of word life and the procedure established by law has changed a lot, and this was the effect of this progressive interpretation, where Supreme Court in number of cases, for instance in Govind versus State of MP, Supreme Court applied this creative interpretation and they decided that right to privacy is also part of right to life. In Permanent Katara versus Union of India, Supreme Court decided that the right to get first aid, medical aid is also part of right to life. In Francis Caroli Mullin versus Delhi Territory, Supreme Court decided the right to life also include right to livelihood. So, through this creative interpretation, the Supreme Court has made informal amendments in the various provisions of the Constitution. The fourth stage which Roscoe Pound suggests in the judicial process is applying the precept or precepts so found and interpreted to the case in hand. To be precise, the judicial process is the name given to the intellectual procedure by which the judges decide cases. It comprehends as the ways of mind, deliberate and subconscious, and all the elements of personality, profession and environment which impel a judge to exercise the judicial power and give judgment. The function of a judge is to decide individual cases independently and to act as a custodian of the law. Impartiality must be assured to fulfill the first function, particularly when judges are required to make value judgments such as reasonableness, fairness and justice. In exercising the judgment, the judge must apply values ultimately derived from those which are prevailing in the community. This is not just an application of public opinion. The judicial function as custodian of the law is essential to maintenance of parliamentary democracy and the rule of law. As a political concept, the rule of law has at least one main strand, the minimization if not the exclusion of human intervention, human arbitrariness from the process of law and governance, and this provided the justification or sound justification to doctrine of stare decisis in the common law system. The doctrine of stare decisis, in addition to whatever it may enjoin upon the intellect, certainly evokes an atmosphere and a mood to abide by ancient decisions, to follow the old ways and confirm the existing precedents. It suggests a condition of rest, even of status, a system of law whose content is more or less settled, the past content by past decisions and the present and future content because they too are controlled by those past decisions. Now, we will discuss the relationship between principle of stare decisis and the doctrine of rule of law. As we mentioned earlier, that principle of stare decisis is important to establish rule of law in a parliamentary democracy. The assumed emergence of new decisions from those of the past would depend only on correct judicial reasoning and not on judicial choice and will, and the notion of stare decisis would thus run into the notion of the rule of law, as in Bracton's famous subjection of king not to man but to God and the law. The principle of stare decisis is thus one way by which the courts respect the legitimate expectations of the community. If we see the principle of stare decisis in Indian judicial system, how Supreme Court and Indian courts applied doctrine of stare decisis. Article 141 of the Constitution provides that the law declared by the Supreme Court shall be binding on all courts in India. This is the foundation of the law of stare decisis, principle of stare decisis. The intent of this provision has transcended well beyond the Blackstonian fiction that judges merely interpret the law. Now, we have travelled a lot where it has been accepted widely and acknowledged by the judges, by the jurists, that judges does not only interpret the law, but judges do make law. Law is to a great extent what judges say it is, and how they say it is one of the primary sources of the legal authority in any state. There is no dispute that judges rely on precedent, but at the same time are also able to devise ways and means to get away from the binding effect of what they feel is a bad precedent. It started appearing from 1920s against the classical doctrine of precedent, and the recent case law suggests that judges are prepared, though with important reservations, to use doctrine of precedent merely to perform the function of maintaining a continuity in the law without allowing the doctrine to prevent them from dissenting from the views of an earlier case. Now, Indian Supreme Court on doctrine of precedent, how Indian Supreme Court has taken doctrine of precedent or principle of stare decisis. Indian Supreme Court favors doctrine of precedent on the ground that the law must be certain. This is one of the basic feature of the law, that law must be certain. Accordingly, some judges would not be very keen to overrule earlier cases. For instance, in Keshav Mills Limited versus IT Commissioner, Justice Gajendra Gadkar laid down a number of reasons for not overruling a case, where he observed that unless considerations of a substantial and compelling character make it necessary to do so, this court would be reluctant to revise its earlier decisions. In famous Bengal Immunity Company versus State of Bihar, where a minority of 3 out of 7 judges is stressed that the power to overrule a case must be exercised sparingly and with caution. However, there was a time in England when the House of Lords declared that the even House of Lords is also bound by its own decisions, but Supreme Court in Bengal Immunity Company versus State of Bihar accepted that Supreme Court is not bound by its own decisions, and Article 141, the phrase all the courts within the territory of India was interpreted as all the courts minus Supreme Court. So, the implication of Article 141 is that the law declared by the Supreme Court shall be binding on all courts except Supreme Court within the territory of India. Justice Hegre also observed in Income Tax Officer Tutikon versus TST Nadar that every time court overrules its previous decisions, the confidence of the people in the soundness of the decision of this court is bound to shaken, meaning thereby the court must resist in changing the previous cases precedents. Few decades later, Chief Justice Y.V. Chandrachud, while emphasizing the importance of rule of state decisis, observed in famous Vaman Rao versus Union of India that for the application of the rule of state decisis, it is not necessary that the earlier decision or decisions of long standing should have considered and either accepted or rejected the particular argument which is advanced in the case on hand. Were it so, the previous decisions could more easily be treated as binding by applying the law of precedent, and it will be unnecessary to take resort to the principle of state decisis. It is therefore sufficient for invoking the rule of state decisis that a certain decision was arrived at on a question which arose or was argued, no matter on what region the decision rests or what is the basis of the decision. In other words, for the purpose of applying the rule of state decisis, it is unnecessary to inquire or determine as to what was the rationale of the earlier decision which is said to operate as state decisis. Despite this declared sensitivity for the rule of precedent or state decisis, the Supreme Court appears to have overruled itself in large number of cases. For instance, an 11-judge bench in I.C. Golaknath versus State of Punjab, AIR 1967, Supreme Court, page 1643, has overruled earlier two judgments of constitutional benches, namely Shankari Prasad Singh Dev versus Union of India, AIR 1951, Supreme Court 458, and Sajjan Singh versus State of Rajasthan, AIR 1965, Supreme Court, page 845. And later, this 11-judge bench decision was also overruled by the 13-judge bench decision in famous Keshwanand Bharti versus State of Kerala, AIR 1973, Supreme Court, page 1461. Supreme Court in Menka Gandhi versus Union of India, AIR 1978, Supreme Court, page 597, overruled A.K. Gopalan versus State of Madras, AIR 1950, Supreme Court, page 27. And in Lakshman Chand Kumar versus Union of India, AIR 1997, Supreme Court, page 1125, Supreme Court overruled its earlier precedent in S.P. Sampath Kumar versus Union of India, AIR 1987, page 386. There are a number of other cases where Supreme Court overruled its earlier decision in order to decide a case and in order to make a new precedent. Now, another important aspect of judicial process and rule of state decisis is the concept of ratio decidendi and obiter dictum, and how the courts apply these ratio decidendi and obiter dictum while deciding cases. Judges, following Lord Campbell in famous Attorney General versus Windsor, describe the ratio decidendi is used to signify the rule of law propounded by the judges as the basis of their final verdict of a particular case. The concept, for example, embraces both the explicit formulation by the judge of a proposition and the implicit formulation, while on the other hand, Samant and several other jurists attributed this phrase the meaning the part of a case that possesses authority. Ratio decidendi means the part of a case that possesses authority is the ratio decidendi, that is to say, the rule of law upon which the decision is founded. This is the meaning explicitly adopted by Professor A. L. Goodhart in his famous article and implicitly by A. W. B. Simpson in his note. Now, we come to Obiter dictum. In contrast with the ratio decidendi, which is the authority of the law, authority of the judgment or authoritative part of the judgment, the obiter dictum, which is mere saying by the way or a chance remark, which is not binding upon the future courts, though it may be respected according to the reputation of the judge, the eminence of the court and the circumstances in which it came to be pronounced. When I mention reputation of a judge, I will give an example that a famous judge of Allahabad High Court, Justice Mahmood, and the judgments given by Justice Mahmood was so respected, was given so high regard that people say that even obiter dictum of the judgments of the Justice Mahmood are binding, and it was actually followed by other courts. Due to the wide ambit of Article 141, all the high courts in India by and large agree that they are bound by even an obiter dictum of the Supreme Court. Justice S. S. Dhawan in Union of India versus firm Ram Gopal observed that it has been overlooked in various authorities cited before this case that the doctrine of supremacy of any declaration of law by the Supreme Court has been made part of the constitutional law of the Republic. It therefore rests on a much loftier pedestal and judicial conventions under which every inferior court is bound to follow previous decision of a superior court. Article 141 had the effect, in addition to investing the decision of the Supreme Court with a binding force, of creating a constitutional organ whose declaration of law pronounced ex cathedra shall be binding on all courts in India. The question which arises here is, what part of the judgment of the Supreme Court is made ex cathedra? Justice Satish Chandra of Allahabad High Court observed and opined that he is not bound by a ruling where argument in the Supreme Court has proceeded on a concession. Several other high courts have also observed that courts are bound by an obiter dictum, but not by casual observations. Justice Chandrachud of the Bombay High Court also insisted that an obiter dictum is binding only if it is a considered opinion. Now, we find several opposite observations by some high courts in the country. This is in contrast with the opinion of Calcutta High Court that ruling of Supreme Court are binding even if point was not argued before the Supreme Court. In Ajaib Singh versus CWT AIR 1969 Calcutta, page 249, the High Court of Orissa has also taken the view to which Madhya Pradesh High Court is also in agreement that even an obiter dicta is binding unless that court made it clear that its view was intended to be a tentative one. We can refer the case in Lakshman Naidu Nandu AIR 1966 Madhya Pradesh 261. Kerala High Court is also of the opinion that judicial propriety demands that even obiter dictum of the Supreme Court should be accepted as binding. Now, if we see the Supreme Court decisions in Kaushalya Devi Bogra versus Land Acquisition Officer, the Supreme Court pointed out that judicial decorum and discipline requires that the directions of the Supreme Court should be taken as binding on the subordinate courts. The apex court in divisional controller case RTC versus Mahadev Shetty observed that mere casual expression carry no weight at all. Not every passive expression of a judge, however eminent, can be treated as an ex cathedra statement having the weight of authority. This view was affirmed by the Supreme Court recently in Girnar Traders versus State of Maharashtra. In Girnar Traders versus State of Maharashtra 2007, 7 SCC page 555, the Supreme Court observed that observations of the court did not relate to any of the legal questions arising in the case and accordingly cannot be considered as part of ratio decidendi. On the basis of above mentioned discussions and reference of cases, we are of the opinion that though there is no authoritative pronouncement of the Supreme Court as to whether Obiter dictum is binding or not, the general perception amongst the High Court is that it is binding if it is not just a casual remark. If we see the implications of the precedential mechanism in India, we can see that in common law we have common law adversarial tradition, where judges are trained as advocates and they must listen to the evidences adduced in the court of law, from which they then construct and balance to arrive at the truth. This expression of what the law is to a judge is a judicial opinion and addresses two matters, result and the region. The precedent affects Supreme Court decisions making in several ways. The conformist opinion explains precedent as a primary region, why judges make decision that they do. The alternate view considers precedent as a normative constraint on judges deciding cases on their personal preferences. On this account, judges have a preferred rule that they would like to establish in the case before them, but they strategically modify their position to take account of a norm favoring respect for precedent in order to produce a decision as close as is possible to their preferred outcome. Our Constitution also gives freedom to judges under Article 145 that judges have to decide cases on the basis of question of law and question of fact, but if judges do not find themselves in agreement with the majority opinion, they have freedom to write concurring opinion or dissenting opinion. This is the freedom which is given by the Constitution to our judges of the Constitutional Court, High Court and Supreme Court, which they exercise very frequently. In exercise of this freedom, the judges write their concurring opinion. Concurring opinion means where judges accept the result of the majority brother judges, but they give different regions. In dissenting opinion, judges disagree with the majority in both the counts, result as well as the region. In this module, friends, we discuss the concept of judicial process, the process by which the judges decide a case. The judges apply doctrine of precedent, how this precedent creates a restraint on the judges and maintains rule of law. We also discussed how Indian Supreme Court has interpreted doctrine of stare decisis or doctrine of precedent. We also discussed in this module the concept of ratio decidendi and obiter dictum, and the Indian Supreme how in Indian courts have applied doctrine of ratio decidendi and obiter dictum. We also see the implications of the precedential mechanism in the Indian legal system, in the Indian judicial system, and how judges interpret the law, the statutes and the Constitution through various rules of interpretation. We briefly discussed the rule of literal interpretation, the rule of golden rule of interpretation. We also discussed the creative interpretation and the progressive interpretation made by the judges in order to make the Constitution or the law more dynamic, more organic. We also discussed the implications of the precedential mechanism in the Indian Supreme Court briefly. Thank you.